There's a lot of misinformation out there about trusts. They're often presented as magical solution to avoid tax or care fees, but that's simply not the case. And what we rarely hear about are the problems that can arise when a trust isn't set up or managed properly. Trusts are powerful, but they're also misunderstood. When handled properly, a trust can safeguard your home and your loved ones. When it's not, it can lead to disputes, unexpected tax bills, and outcomes you never intended. Hi, I'm Jim from ELM Legal Services, and in this video we're going to separate fact from fiction. I'll show you why people use trusts, what can go wrong when they're not set up or managed properly, and how to make sure yours really does what you intended. Let's jump right in. First of all, let's take a moment to recap what a trust actually is. Now, a trust is a legal arrangement that lets you set aside assets like money, property or investments for the benefit of others. The person who sets it up is the settlor, the people who manage it are the trustees, and those who benefit are the beneficiaries. There are two main types of trust. A will trust takes effect after you pass away, while a lifetime trust starts as soon as you transfer assets into it. Both can be powerful tools for protecting your family and your assets, but they work in different ways. We have a dedicated video on the subject linked in the description, so now let's look at the most common reasons people choose to set one up. Reason 1. Supporting blended families. One of the main reasons people use a trust is to protect children in blended families and prevent what's known as sideways disinheritance. Now, this happens when assets that were meant for your kids ends up passing to a new partner or even that partner's family. That's after you're gone. A trust can prevent this by giving your partner the right to live in the family home or receive income for life, while ensuring your share of the home or savings eventually passes to your kids. It provides security for your partner and peace of mind that your kids will still receive their intended inheritance. For a deeper look at how sideways disinheritance happens and how to stop it, you can watch one of our dedicated videos linked below. I'd highly recommend that one if you're in a blended family. Reason 2. Providing for children and young adults. A trust lets you control when and how your children receive their inheritance. Instead of them inheriting everything at 18, you can delay access until they're older or more financially responsible. In the meantime, trustees can use funds to support education, housing or other essential needs, while keeping the rest of the inheritance safe until the right time. Reason 3. Protecting vulnerable loved ones. If someone you care about has additional needs, money troubles or difficulty managing finances, a trust offers long-term protection. Trustees can make payments only when it truly benefits them, while shielding the remaining funds from poor spending, debt or outside influence. This ensures ongoing support without putting their future security at risk. Reason 4. Preserving the family home and tax allowances. A trust can protect your family home, and if set up properly, it can help keep valuable inheritance tax allowances like the residence nil rate ban, which is currently up to £175,000 per person when a home passes to children or grandchildren. If you leave your home straight to your kids, that allowance usually applies automatically, but many people also want to make sure their partner can stay in the home after they're gone. If the home passes directly to your kids, they become the legal owners, which can cause problems. They could sell it, or their share might be affected by divorce, debt, or even their own passing, leaving your partner without a home. If you leave it outright to your partner instead, they're secure for now, but they own it completely. They could sell it, leave it elsewhere, or it could be used to pay for care. The residence nil rate ban isn't used at that point, though if you are married or in a civil partnership, it can normally be transferred and claimed later. A life interest will trust solves both issues. It lets your partner live in the home for life while ownership stays safely in the trust. That protects the home and ensures it eventually passes to your kids. And when drafted correctly, HMRC treats it as if the children inheriting, so the residence nil rate ban still applies. If you're not married, the trust can still protect your partner's right to stay, but it won't usually preserve the tax allowance, as transfers only apply between spouses or civil partners. Reason 5. Managing business and agricultural assets. A trust can help keep family businesses or farms running smoothly after you're gone. Trustees can manage these assets responsibly and help ensure they stay within the family. With the right advice, qualifying assets can benefit from business property relief and agricultural property relief, which can significantly reduce and in many cases remove inheritance tax, helping to preserve the family enterprise for future generations. From April 2026, however, these reliefs are being capped and reformed, so tailored advice is essential, particularly for larger farms and businesses. Reason 6. Passing on life insurance quickly. Putting a life insurance policy or death in service benefit into trust means the payout goes straight to your family without waiting for probate. This gives them quick access to money when it's most needed. And if set up correctly, they can also keep the proceeds outside of your estate for inheritance tax. So more of the money goes to your loved ones. Reason 7. Protecting assets from outside claims. Now, a discretionary trust can protect family wealth if a beneficiary divorces, gets into debt, or faces legal action, because the assets belong to the trust, not the individual. They're generally shielded from outside claims, helping ensure your inheritance stays within the family. Reason 8. Controlling timing and conditions. Trusts let you decide who inherits when and under what circumstances. You can release funds at key life stages such as adulthood, university, or buying a first home, or even stagger inheritances to encourage financial responsibility. This ensures support is given at the right time and in the right way. Reason 9. Ensuring privacy and continuity. Assets in a lifetime trust can usually be passed on without probate, keeping the process faster, smoother, and private. This avoids delays, legal costs, and public disclosure, ensuring your estate is handled discreetly and your loved ones can move forward without unnecessary stress. Trusts can offer great benefits, but they are also complex. The rules are detailed, the wording must be precise, and trustees carry serious legal responsibilities. Mistakes in drafting, setting up, or managing a trust can lead to disputes, unexpected tax bills, or even the trust failing altogether. These problems are more common than many people realize, and they can be stressful and costly to put right. Here are the main problems we see, why they happen, and what the consequences can be. Problem 1. Choosing the wrong type of trust. Now, not all trusts work in the same way. Each has its own rules, tax treatment, and level of control. If the trust type doesn't match your real goal, the results can be serious. For example, a family wanting the surviving partner to stay in the home for life with the children inheriting later. They chose a discretionary trust because it seemed flexible. However, discretionary trusts give trustees wide powers, meaning they could technically refuse the partner's right to stay. This led to uncertainty and disputes that could have been avoided with a life interest trust, which would have guaranteed the partner's rights while protecting the capital for the kids. Problem 2. Vague or faulty drafting. A trust is only as good as its wording. If instructions are unclear, trustees and beneficiaries can easily disagree about what was meant. For instance, if your will says your partner can live in the house but doesn't say whether they can sell it and move to a smaller property, the trustees might refuse. Or, if it's unclear who must pay for repairs, conflict can quickly arise between the partner and the kids. Problem 3. Home ownership not aligned. If you and your partner own your home as joint tenants, your share automatically passes to the survivor when you die. This transfer happens outside of your will, so any will trust cannot take effect over that share. If you want a protective property trust to apply, you must first sever the joint tenancy, so you each own a distinct share as tenants in common. Only then can your share pass into the trust under your will. Problem 4. Trusts not funded. Sometimes a will creates a trust, but the assets are never properly identified or transferred. For lifetime trusts, people may set them up but never move anything into them. An empty trust has no effect. Trustees have nothing to manage and beneficiaries have nothing to receive. Problem 5. Poor trustee choices. Trustees carry legal responsibilities. They must act fairly, manage assets properly, keep records, and follow the trust terms. Choosing the wrong people, for example, someone unreliable, biased, or disorganized, can cause serious problems. Poor trusteeship can lead to delays, unfair treatment, financial loss, or even legal action. In many cases, appointing at least one independent or professional trustee can help prevent this. Problem 6. No letter of wishes. Some trusts, such as discretionary trusts, are deliberately flexible. That flexibility only works if the trustees understand what you wanted. A letter of wishes is a separate document that guides your trustees on how to use their discretion. It's not legally binding, but it's extremely useful. Without one, trustees are left to make decisions without clear direction, which can lead to conflict or inconsistent outcomes. Problem 7. Since 2017, most UK trusts must be registered with HMRC's Trust Registration Service, unless specifically exempt. Trustees must also submit annual tax returns if income or capital gains arises. They must pay any tax due and maintain accurate records. Failure to register or file returns can result in penalties, loss of tax reliefs, or even personal liability for the trustees. This is a common and avoidable problem. Problem 8. Tax traps. Contrary to what many people think, trusts do not avoid tax. They come with their own set of rules, and ignoring them can cause large, unexpected bills. Let's have a look at some of these rules. Regarding inheritance tax, or IHT. If you move money or property or investments into a lifetime trust whilst you're still alive, the taxman may treat this as you gifting the asset away. If what you put into the trust is over your available allowance, which is currently £325,000, the excess can be taxed at 20% straight away. Many lifetime trusts also face a check every 10 years where up to 6% of the value in the trust can be charged, and smaller exit charges when money or assets are paid out of the trust. Regarding capital gains tax, or CGT, if you put something into a trust that has gone up in value, the law often treats it as if you had sold it, and capital gains may be due on the profit. For example, you bought a property for 100 grand. It's now worth 300,000. You move it into a trust. For CGT, it can look like a £200,000 gain, and tax may be charged on that. Holdover relief is a way of delaying this tax, but it's only available for certain assets and certain types of trust. If the rules are not met, the capital gains tax bill can arrive immediately when you move the asset into the trust. Regarding stamp land tax, or SDLT, if you move a property into a trust and that property has a mortgage, there can be a stamp duty land tax to pay. Why? Because HMRC often treats the transfer as if the trust has bought the property by taking on the mortgage debt. So even though no money changes hands, the trust is seen as paying the amount of the mortgage, and stamp duty can be charged on that. Then we have gifts with reservation of benefit. This rule stops people pretending to give things away while still enjoying them, as if nothing has changed. For example, you move your house into a trust. You still live there, rent-free, just as you did before. HMRC can say you still get the benefit, so we will act as if you never really gave it away. That is called a gift with a reservation of benefit, and the result, the house can still be counted as part of your estate when you pass away. So its full value can still be hit by inheritance tax. And To boot, you would have lost control of the house and kept the tax bill anyway. Finally, lost tax allowances. There are some very helpful tax allowances in the system. For example, the residence nil rate band linked to the family home, and reliefs for trading businesses. If a trust is not set up in the right way, these reliefs may not apply, or only part of the relief is available. That can mean your family pays more tax than necessary, especially where a home or family business is involved. Problem 9. Deprivation of assets. Some people set up trusts mainly to reduce what they might have to pay towards future care fees. This can be classed as deliberate deprivation of assets. Now, local authorities can review the reasons why a trust was created. If they believe the main aim was to avoid paying for care, they can treat you as still owning those assets. That means the trust won't protect them from care fees. There's no fixed time limit after which a transfer is automatically safe. Even if the trust was created years earlier, if avoiding care fees was a key motive, the local authority can still challenge it. If the intention behind a trust isn't genuine estate planning or family protection, but purely to avoid care costs, it may fail to achieve its purpose and create extra complications for your family. And problem number 10, out-of-date planning. Families and laws change over time. People remarry, new kids, grandchildren are born, relationships change, tax rules are updated. A trust written 10 to 15 years ago may no longer suit your circumstances. Regular reviews are essential to keep your planning up to date and effective. By now, we've seen how valuable trusts can be and how easily things can go wrong if they're not set up or managed correctly. The good news is that most issues are preventable with clear planning, good drafting, and proper administration. Here's a practical checklist to help ensure your trust works as intended and continues to serve your family well. Number 1, be clear about your goals. Every trust should start with a clear purpose. Think carefully about what you want to achieve, whether that's protecting a surviving partner, safeguarding children's inheritance, managing funds for young beneficiaries, supporting a vulnerable relative, or keeping a family business intact. Different goals require different structures. Being precise about your priorities helps your advisor recommend the right type of trust from the outset. Number 2, choose the right structure and include the right powers. Once your goal is clear, choose the form of trust that best fits it, such as a life interest trust, discretionary trust, or bare trust. Each comes with distinct tax implications and levels of control. The trust deed, or will, must also include the necessary powers for the trustee, such as the ability to move to a replacement property, invest income, or delay distributions until a beneficiary reaches a certain age. Missing or unclear powers can restrict flexibility or cause disputes later. Number 3, align that property ownership. If your plan includes protecting the family home through a will trust, your ownership structure must support it. When property is owned as joint tenants, your share automatically goes to the survivor outside of the will, so it can't enter the trust. Severing the joint tenancy and owning as tenants in common allows your distinct share to pass into the trust on death, ensuring your intentions are carried out exactly as written. Number 4, appoint capable and trustworthy trustees. Trustees are the cornerstone of a successful trust. They have legal duties to act impartially, manage assets responsibly, keep accurate records, and follow the terms of the trust. Choose people who are reliable, financially responsible, and able to make balanced decisions. It is usually sensible to have at least 3 trustees, for example, a mix of trusted family members and, if you wish, a professional who can add technical knowledge. Number 5, write clear letter of wishes. For trusts that give trustee discretion, clear guidance is absolutely essential. A letter of wishes sets out how you'd like the trustees to use their powers, for example, to ensure a partner can stay in a home for life while protecting capital for the kids. Although it isn't legally binding, it does provide valuable direction and reduces the chances of misunderstanding. Including practical examples such as paying for education or helping with a house can make your intentions even clearer. Number 6, maintain proper administration. A trust doesn't end once it's created. It must be maintained. For lifetime trust, administration starts as soon as assets are transferred in. For will trusts, it begins after the death when the trust comes into effect. Trustees must register with HMRC's Trust Registration Service and file tax returns and keep accounts, review investments and record all key decisions. Consistent administration avoids penalties, protects tax reliefs and ensures transparency for beneficiaries. Number 7, review regularly. Life and legislation change over time. Marriage, divorce, birth, death and tax updates can alter how a trust operates. A review every few years or after any major life event keeps your trust aligned with your circumstances and current law. Regular updates prevent small oversights from becoming costly problems later. Trusts are powerful tools, but they're also complicated. Success depends on more than just picking a trust type. The wording has to be precise, trustees need to be capable and reliable, and the trust has to be managed properly over time. Even small mistakes in these areas can cause disputes, tax issues, or mean that the trust fails completely. This is why professional advice really matters. At ELM Legal Services, we take time to understand your family's situation, explain your options, and help make sure everything is set up and managed correctly. We also keep plans under review so they stay effective as laws change and family circumstances evolve. But please, don't simply take my word for it. Do your own research. Look at reviews and find a professional you feel comfortable with and who suits your needs. Whether that's us or someone else, the most important thing is that you get advice you can rely on, so your trusts and planning protect your family exactly as you intended. That's it from me. So if you found this video helpful, please like, subscribe and share it with anyone who could benefit. Remember, a little planning today can make a big difference tomorrow. So until the next time then, stay safe, stay informed and stay tuned.